Hello and welcome to your #1 legal talk show, The Courthouse. The Courthouse is where we get to learn the law in plain, simple and entertaining language. You get to hear legal jargons, legal concepts, legal maxims with our panel of experts telling you all you need to know about the law every week on the station. I am Itohan Olomu-Agbodo. We'll go on a quick break, and when we return, we'll let you know what we'll be discussing this week on the show. Stay with us.
Plus app is bigger and better. Watch all our shows with just a click.
Let him have the right to decide what happens with your body.
Watch inspiring, informative and entertaining programs. You can comment, like and share. Watch our live TV and web TV on your mobile devices. Watch the big stories in real time or when you have the time. Experience Lovewell Plus app right now. Download Lovewell Plus app on Android, iOS and BlackBerry. Go to Google Play Store, Apple App Store or Windows Phone Store. Welcome to the bigger picture. Lovewell Plus, beyond television.
You're welcome back. If you just joined us, this is the Courthouse, and I have a legal practitioner based in Nigeria with me. He is Evans Ufeli, and he's the principal partner of Evans Ufeli & Co., a firm of legal practitioners. Thanks for being with us on the Courthouse this week.
Thank you very much.
Okay, so as I said, common legal misconceptions. I saw you wrote an article about when people hear that a case is closed or the prosecution closes its case. What does it mean? Because a lot of people in recent times, they were interpreting a scenario where the suspended Chief Justice of the Federation of Nigeria, we heard that the case had been closed against him, and it turned out to be different. So can you throw some light on that scenario?
Apart from the public misconception, I think the media also started the misconception itself, because some of the headlines went this way: federal government, closes case against the embattled Chief Justice of Nigeria, who is in the eye of the storm right now for allegations of non-declaration of assets, as it were. But the right interpretation to that is usually in criminal prosecution, when a party or a person or the defendant or the accused, depending on the jurisdiction where you are,
yes,
is charged to court, is arraigned. Upon arraignment, the prosecution will open its case.
Okay.
And when we say the prosecution opens its case, what do we mean? It means that the prosecution will bring evidence to back up the allegation for which the accused persons have been accused of the offense, rather committed. So in that case, the prosecution will take time out to tender evidence, documentary evidence, call witnesses. Okay. And then these witnesses will corroborate the charge against the defendant or the accused person. And then the standard is supposed to be beyond reasonable doubt. And that is why the prosecution will have to work very hard, okay, to make sure that it proves its case. Then when the prosecution has tendered its witnesses, has called his witnesses and has tendered all his evidence, the prosecution will now close its case. And that is what happened in this case. The prosecution was supposed to call 6 witnesses, and then they called 3. And after the 3 were called on that particular day, the federal government, okay, decided that it's not going to call the remaining 3 further witnesses. Okay. And so they have it's their prerogative. They can decide to call one out of the 6 listed. Okay, it's not compulsory that if you list 6, you must call the 6. Okay, so what happened is that they now closed their case, and then the court was to adjourn for the defendant to open its case. Okay. You understand? And in doing so, the defendant is expected to disprove, okay, whatever allegations have been leveled against him. And then there are 3 options left for the defendant. And the options are that 1 is either the defendant enter a defense and then call witnesses to disprove whatever the allegations were, or to disprove whatever the evidences were in the prosecution's case. It's either he entered defense, or he brings what they call a no-case submission. A no-case submission is required where during cross-examination, the prosecution's case have been so destroyed that no reasonable court can convict on the basis of the evidence they have tendered. So when the defense counsel have so destroyed the prosecution's case, or has so reduced the evidence such that it cannot really hold water, such that the court cannot rely on it to convict, having, decide to bring issues that will deflect the so-called evidence of the prosecution, then you can bring a no-case submission. A no-case submission is telling the court that the defendant have no case to answer. That with the evidence of the prosecution, having gone through cross-examination, the court can see clearly that there is no allegation, that the charge has failed. And when a charge fails against the defendant, it means the trial has failed. Failed. That is, the case against the defendant for which the prosecution took the defendant to court has failed. There will be no need to enter defense in this case. We just bring a no-case submission. And then the court will now look at the no-case submission and look at the case of the prosecution and then decide whether or not it truly have a case to answer. Okay. So the third one is, the third one is that the defendant can decide to rest his case on that of the prosecution. Can say, you know what, I'm not bringing a no-case submission, I'm not calling any witnesses, but I'm asking the court to look at the evidence, to look at the case of the prosecution, and suo motu, decide whether or not there is a case here. You understand? That is resting its case in that of the So those are the three options. One, to bring a defense. The second is to bring a no-case submission. And the third is to rest its case. The defendant rests in the case of the prosecution. So it is now the prerogative of the defendant to choose which option best suits its case. If it's to enter defense, if it's necessary, if it's to bring a no-case submission, or to rest its case. But remember, when a no-case submission fails, it is incumbent on the defendant to file a defense. Okay, so I was going to ask that if you've entered a no-case submission, for instance, and the court rules on it, what are the outcomes, the likely outcomes? Like you said, it may fail. If it doesn't fail, the case will be struck out, or what's... If it does not fail, the defendant will be discharged and acquitted. Discharged and acquitted. Yes, which automatically means the case is terminated. Okay. It depends. It's either the defendant is discharged and acquitted, or the defendant is discharged. They have two different things. So let us know. That's why we're looking at common legal misconceptions today. When a defendant is discharged and acquitted, it means that the defendant, the case is res judicata. You've gone Latin now. Res judicata means that the defendant cannot be tried on that same offense again. Okay, is it the same as double jeopardy? No, it's different from double jeopardy. Double jeopardy is when he's now being tried for the same offense, or when he's about to be tried for the same offense for which he has been convicted, or discharged and acquitted. Okay, so now res judicata. Res judicata is that the court have decided the case. Okay, the court have given judgment, and in that judgment, the court has exonerated the defendant. You understand? In which case, he cannot be tried again on that same charge. Okay, so that's where double jeopardy will not come in eventually. Double jeopardy is when you want to try him. When the state want to try him on those same charge after he has been discharged and acquitted. Do you understand? Very interesting. Then the question of discharge, like yesterday I was in court, the case I was called before the accused person who was in court have been in court 5 times, and the prosecution have not been able to assemble its witnesses. And it is, a charge of kidnapping, which carries death sentence in Lagos State by virtue of the law 2017. Now, the judge said, if he gives you 4 chances, and on the 5th one, the prosecution is not able to bring its witnesses, because that is what the case is technically withdrawn. And you know what he did? He discharged the defendant.
So
he didn't discharge him and acquit
him.
He told the prosecution that whenever you are ready again, you can still go and arrest him. And then when you are ready, when you know you are sure that your witnesses have been assembled, you can rearrest him and then charge him again because he has been discharged. It means that it's not on the merit. It's based on the technical clinch that the inability of the state to provide witnesses to prove the case against the defendant. So the defendant was discharged. And from there, the court have ordered that from there he goes home, not to the prison custody.
Straight
so the
home.
warder, yes. So from there he went straight home. And that is what it is. So that is why the prosecution is expected, not as a persecutor, but as a prosecutor of the state, to make sure that it is diligent, so that you can prosecute adequately, so that the court will not discharge all these alleged criminals, okay, or suspects, you understand, into the society. Who knows whether or not they are guilty of the offense? At this stage, you can't tell. So they may go and perpetrate such crime. That is why the prosecutors of state are enjoined or encouraged to make sure that they're able to assemble their witnesses to prove the allegations they have against the defendants.
Okay, quite interesting. So now you've given us another one: discharge and acquit. To discharge and acquit a suspect, a defendant in a criminal case. So now let's take a look at taking a plea of not guilty versus someone being seen as guilty.
Yes.
The impression, like you said, sometimes is as a result of media trials.
Yes.
Yes. So some people attempt to have committed an offense even before they are tried. So when they go to court and you hear them pleading not guilty, people are angry. They are like, why? He did this thing. Why is he pleading not guilty? You understand? So help us shed some light on the plea of not guilty.
Well, on the issue of the plea of not guilty, you see, I think some of the times when people are arrested for offense, the public perception, especially in uncivilized society, is that upon allegation, the person is guilty. And that is wrong. By Section 35, subsection 1 of the Constitution, Section 36, the Constitution says that every accused person is innocent until proven guilty. You understand? And that presumption of innocence is the constitutional safeguard of the defendant, so that he can be truly tried before. But when they get to court and the defendant takes a plea of not guilty, it is expected that he be tried on the offense. He's not supposed to plead guilty. Even when a defendant pleads guilty before the court will enter not guilty for him.
I was going to say, what if he pleads guilty?
No, if he pleads guilty, the fact that he pleads guilty does not mean that the prosecution will not prove its case. The law is that the prosecution must not rely on the weakness of the defendant's case, but on the strength of its own case. That is to say, because we've had situations where an accused person is arraigned before a court, you know, he's asked whether he's guilty or not, and he keeps mute. You understand?
Yes.
And when he keeps mute that way, the court will have to investigate what the problem is, whether it is vindictive, whether it's as a result of malice, or as a result of the visitation of God. Okay? So those are issues. But where, sometimes in a magistrate court or in court of summary jurisdiction, where the defendant pleads guilty, and he's ready to be tried in the court, and he's ready to be convicted summarily, like the Federal High Court, the state, the magistrate court, the judge can convict. But in the High Court, okay, a court of record, a court that has wider jurisdiction, wider, so you cannot plead guilty and then the judge will now sentence. No.
Based on that.
Even if he plead guilty, the judge will enter a plea of not guilty for him so that the prosecution will prove its case. Because the reason is that the defendant can say he's guilty not knowing the implication of what he's saying. You understand? So apart from the fact that he has made pronouncements, which is perhaps a confessional statement, the prosecution must still prove its case to bring evidence to corroborate the plea of guilt of the defendant. So that must be done before you can. The reason is because it is better to free 99 criminals
than
to convict one innocent man. In
innocent
Garba versus the state, the heavens wept because the defendant was convicted without proper, trial. And it was adjourned that the state must not fall into such kind of situation. That if the state want to protect society, the state must not be seen as a party in crime for which it has set itself out to correct. The state must not also commit the same crime it has set itself out to correct. And that is the position of the law.
Quite interesting. Well, we've been listening to Ufeli Evans. Is a legal practitioner based in Nigeria, and he's been clearing up some common misconceptions in the law. People generally tend to hear that the prosecution has closed its case and they believe that's the end of the matter. But no, he just told us that it's the beginning of the defendant's case. The defendant then opens his case. He also cleared the air about the difference between being discharged and acquitted. There are two different terms. And he also talked about entering the plea of guilty or not guilty. A defendant is entitled, based on the Constitution, 1999 Constitution, Section 33, up to 36 and 40, where we have constitutional safeguards for an accused person. An accused person can enter a plea of not guilty. It's his right. So we'll take our legal nuggets and I'll be right back with some more common misconceptions. You're welcome back. If you just joined us, this is the Courthouse, our Law Class 101, and we've been talking about common legal misconceptions, some terms that you feel you know, but you need to have more information about. And we've been talking about taking a plea of guilty or not guilty, closing a case or ending a matter. We also talked about being discharged and acquitted. There are two different terms. And now we will be talking about striking out a case and summary judgments. Because sometimes we hear about striking out, sometimes we hear a court order, a court ruling. Help us clarify. Okay, I think we should just go to the difference between ruling or a judgment.
Okay, the difference between a ruling and a judgment is that a ruling applies when the substantive suit subsists. That is during the pendency of the substantive suit. What I mean is this. If the substantive suit is, for example, title to land, if the dispute for both parties that this party A say I own the land, party B say I own the land, both of them will file their process. You file your statement of claim, the other one file the statement of defense. Then you front load all the documents that pertain to the case. Okay? Now, if a particular party wants the court to do something, like a particular party wants the court to grant an injunction, like people are in the land, they are about to break the place, to invade the place, the other party is bringing bulldozer and everything. You can bring an application, a motion, okay, for interim injunction. That motion, once it is filed, ex parte, and then you put the other party on notice. When the other party file a counter affidavit and all that, the court will rule on it. So that is not the substantive suit. Okay. The substantive suit is tied to.
It's the main action.
Yeah, the main action. But then there is, a party is making an application, asking the court to take certain action pending the determination of the substantive suit. So those actions that he wants the court to take, he brings it in form of a motion. Because you can't just go to court and tell court orally that you want court to do this. You must bring it in a way of motion. And the court, in addressing it, must rule on it. So because the court rules on applications, then the court now gives judgment on the substantive suit.
Okay.
So that's the difference.
So the ruling, a ruling, therefore, is it the same as an order?
A ruling, from an application, you make certain prayers, ask the court to grant certain orders. Okay. When the court grants any of them, is an order.
It's an order.
Yes, but the court can suo motu on its own. What it means in Latin is suo motu on its own. Yeah. Decide to ask party to maintain the status quo ante.
Gone Latin again.
Yeah, that is, we can't go through law without Latin. So that for both parties to maintain the status quo, so that the court, was before. Yes, before anything, so that the court can finally move on and then decide what to do. And I was going to talk about also in criminal law, because it's very important people know this. When a crime has been committed, the defendant or the prosecution must prove two things, and that is actus reus and mens rea. There are two important elements, the physical act and then the mental act. Intent, yes. You understand? If they say he used a knife and killed someone, or a cutlass and killed someone, then we have the cutlass before us, or we saw him with a cutlass. It means that the first stage has been proved. With the blood and all that, it has been proved that he used the cutlass. But you cannot convict on the basis of that. You also need to check his mental state, that's a mens rea, whether he has the mental capacity or the intention to kill. You understand? Yes. So that you can preclude it from accident, so that you can prove from other eventualities. So you now have to prove that. How do you now prove that? You must make sure that you evaluate his intention to do that. It is when you find him guilty that he intended to kill, based on the action, what he did and all that. That is when you can now go further to convict. Because there's a case, one case sometime at DBC versus the state, there's this madman who walks around in the night. Anytime he passes through a junction, he finds this man always drunk, and the man goes there and just lies down till the next day. It's anytime he wakes up, he goes home. So one particular day, the madman looked at him, decided to use a knife, and then cut off his head. Oh. He cut off the man's head brutally. And when he got to court during trial, the judge wanted to find out why he did that. And he told the judge that he never wanted to kill the man.
He just wanted to find out if he was alive.
What he did was that he wanted to remove the man's head, so that when the man wakes up and discovers that he has no head again, he will not decide what the man will do. So with that, it was clear that his intention wasn't to kill, but his mental state. You understand?
Yes.
And that is the analogy. He was discharged. And then the public will say that the judge has collected money.
That's another thing.
That we saw him, we all came out, we saw the knife.
We saw the blood.
Do you understand? But all you saw was a physical act. Oh. And that has been proved. But the law says you must prove the mental act. And then in proving the mental act, we found out that he had no intention to kill. You understand? When they say this person kidnapped, this one killed, this one or that, they should know that two elements must be cleared before the courts. The physical act and the mental act, which is the actus reus and the mens rea. So that the public don't go and say the judge has collected money and then release the accused person. Okay,
you mentioned motions when you're talking about interlocutory or interim injunctions. Yes. You mentioned ex parte. Yes. We hear ex parte sometimes. So let's know what that is.
A motion ex parte is an application where the other party is not put on notice.
Okay.
Let's take, for example, now, you want an order of court, an order of Anton Piler. Anton Piler has to do with copyrights. Okay. If, for example, this is a warehouse where they stored pirated books, and the books harm the author, my lawyer now wants to bring a motion before the court to grant us an order to seal the place. If you put the other party on notice, they will come and remove all the books. Because they've seen what you're asking the court for. Yeah. You understand? And then when you're talking about injunction also, you're talking about service by substituted means. Okay. If you want to serve harmless motions, really, if you're trying to serve a particular person, a process, court process, service is supposed to be personal. You are unable to serve him You understand? And then you want to bring a motion for substituted service. For you to serve him by either pasting or by publication, you have to come by motion ex parte, because you have not been able to serve him the raw process. So if you do the motion on notice, if you do it motion on notice, you can't even still serve him. And then because the motion is harmless also, the other party need not be heard.
Okay.
The court will grant the order, and then you go and paste or publish.
Very interesting. I know the law is quite interesting, and
yes,
because of these misconceptions, we had to talk and talk and talk. Quite interesting. I know you go on, you'd even bring out some more misconceptions, but probably we'll continue in another episode. We have the bar book segment. I know you know that. So what's your favorite? You've actually mentioned a number.
I think we can just use
So we
one.
should rest on those ones you've mentioned.
Yes, you can rest on those ones.
I'd also rest on suo motu, because you mentioned that too.
Yes, yeah.
So let's get to see some more Latin maxims on our bar book segment. Stay with us. You're welcome back. Well, that's the much we can take this week on the Courthouse. And I want to say a very big thank you to Evan Sufeli for making this discourse very interesting.
You're welcome.
I would like to see you some other time. Okay. So if you have comments for us, we would like you to log on to our website on www.loverplus.org and send SMSs, as I said earlier, to the number that we're showing on your screen now. And we'd like you to keep those questions coming in. We have legal experts standing by every time to provide answers. I am Olomu-Agbodo, and I say, don't just get mad, go get a lawyer. See you next week.